Starting.
I just signed in, so let me start typing questions here.
Okay. Hey guys, it's Tyler Flood, Houston, Texas DWI defense lawyer. Starting 1 minute early. We're still trying to figure this Google Plus Hangouts thing out, but we're getting better at it. Thanks for your patience. And we're coming to you live from my backyard today, and it's raining. It started raining on us in the backyard. So if you hear a little thunder in the background, it's real, and adds a nice little texture to the web chat. Looks like it's going to be raining for the next 4 days in Houston, so be careful out there on the roads. So we're going to talk for about 30 minutes today, and we've decided to talk about specific subjects instead of just random questions that don't have a consistent theme. And today we're going to talk a lot about blood draw warrants and blood draw procedures, breath test versus blood, how you fight blood draw warrants, and things like that. We do have one question, though, before we get started. A couple general questions. And I want to thank you for tuning in, and I'd encourage you to ask your friends to tune in next Friday. We're going to be doing this every Friday until more people tune in, and we scare up some more interest, and I appreciate you sending your questions. Let me tell you, before the event on Fridays, you can always email us questions ahead of time that we can answer, and email those to office@tylerflood.com, and we'll answer those on the next web chat, which is next Friday at 2 o'clock. So someone asked, what are the danger spots for DWI in Houston? So I'm guessing that means, like, where is it most dangerous to drive in Houston, and where are most of the arrests made? Well, right now, without a doubt, the most dangerous place in Houston is Washington Avenue, close to downtown, which happens to be where we're going to be building our new office building. It's right in HPD's backyard. They're just down the street, and it has been a boom for new businesses, new bars and restaurants over the past few years. It's had a complete resurgence, and the problem with Washington Avenue is that the speed limit is still 30 miles an hour, and it is it's a very low speed limit. It's not suited for that road. So it's ripe for officers to sit out there and just pick people off one by one. Even in the morning and afternoons, I see officers that are parked in the turn lane in the middle of Washington or on a side street with a radar gun. If you go 35 or 40 down Washington Avenue, you're going to get pulled over for a ticket during the day. And at night, if you're not going exactly 30 miles an hour, if you go maybe 31 and you've had anything to drink, that's dangerous. So there are so many bars around that place. They hang out at Kung Fu, outside Kung Fu a lot. That social place. There's a lot of bars that are hot spots, but anywhere on Washington Avenue, if you've had anything to drink at night, don't drive your car down Washington Avenue unless you can drive 30 miles an hour and stay inside the lanes. But it's never drive while you're intoxicated, first of all. But that's the place right now that people are getting arrested the most for DWI. And the Harris County DA's website, they even acknowledge that on their website. They say that Washington Avenue is the #1 hotspot for DWI arrests. So be careful out there. If you're going to go out around that area at night, I'd say Uber it and stay out of jail. All right? Okay. I'm going to mark that one as I don't know how to do that. Okay. So I see. Okay. Okay. The new question is, are you allowed to request an attorney if you are under suspicion for DWI? That's a really great question. You should request an attorney if you are being investigated for DWI. You're not necessarily allowed to have an attorney throughout the investigation process. The law right now is settled on the idea that you're not entitled to an attorney through certain phases of the investigation. You are entitled to an attorney before you give any evidence that's testimonial in nature. And if you've been Mirandized, or if you're in custody and they start questioning you, you have the right to remain silent. You have the right to an attorney. But when you're out on the scene, and even if they have you in handcuffs, which you would think means that you're under arrest and that you're in custody because you can't leave the scene, the officers and a lot of really bad case law decisions have held that you're not in custody, even though you're in handcuffs in the back of the car and you're not free to leave the scene. Officers are still free to question you about where you were, what you had to drink, and they can use that as an exception to the hearsay rule to try to formulate probable cause. I don't agree with it, but you're not entitled to an attorney when you're just being investigated for DWI. While you're out on the road, they're asking you, where have you been? How much did you have to drink? Do you feel like you're intoxicated? You start saying, I'd like an attorney right now. Unfortunately, they don't have to stop their investigation, and you're not legally entitled to an attorney at that point, but do keep requesting an attorney at that point, definitely. So when you're doing field sobriety tests, the courts have determined that doing the walk and turn, where you walk a line, turn around and come back, and you balance on one leg, also known as the one-leg stand, that those tests are non-testimonial in nature. Go figure that. They say that because you're not answering any questions and that they are just physical, I can't remember the exact terms, but they're not, you're not giving testimony. So you're not entitled to have an attorney during the field sobriety test, which doesn't make sense at all either. So then you're arrested, you go back to the station, and people request an attorney before they decide whether or not they're going to take a breath test or a blood test. Unfortunately, you're not entitled to an attorney at that point yet either, according to the law, which again, put a disclaimer on there, I do not agree with that. But that's the way the case law is right now. And at some point after they finish their entire investigation, then they will read you your Miranda rights and then tell you, now you have the right to have an attorney, and you should request that. It's kind of funny. Some people say, I'd like to call my attorney right now. And some of the veteran officers will say, great, here's my cell phone. You can call your attorney right now, and people don't have anybody to call. So it's kind of funny. If you're going to request an attorney, keep an attorney's name and number in mind, okay? One attorney I can think of off the top of my head is Tyler Flood, and our number is 713-224-5529. A lot of people put that number in their cell phone just in case you're in that situation, and I have had people call me before when officers have let them call their attorney, and I have been able to give them advice when they're being investigated. So it certainly is a good idea to request an attorney at all stages. You might get lucky and they might let you call me, or whoever your attorney of choice is, and you can advise people what to do in that situation. Okay. All right. Hey, Tyler, question for you. Does someone have the choice of choosing breath or blood? The answer to that is no. The officer is the one that chooses if he wants to get a breath or blood specimen from you. On the DIC 24 paper that they read to you, it said they go through the long list of statutory warnings that they're required to read to you about what happens if you consent to a breath or blood test or refuse a breath or blood test. But and at the end they say, I'm now requesting a specimen of your, and there's two boxes they can check, and they can ask for breath or blood. I think they should always ask for breath and blood and let you choose, because if they don't ask for breath and then only ask for blood, I think you've got a good argument to make that that's an unreasonable search and seizure under the Fourth Amendment of the U.S. Constitution. It's supposed to be by the least intrusive method possible, and if they didn't give you the option of just blowing into a machine at all, then stabbing a person with a needle is not the least intrusive means that they could have used to obtain a specimen against you. So I've seen people argue with them and say, look, I'll give breath but not blood. They can choose what they want. Again, I don't agree with that. I don't agree with most of the laws surrounding DWI right now, but that's what we do. Every day we battle these cases in court and fight them. Okay, next question. So what is a 15-minute observation period, and how do you that it did not happen when the officer says that it did? So if you decide to blow, an officer is required to observe you for 15 full minutes, not 14 minutes and 59 seconds. It's statutory. It says 15 minutes to make sure that you don't put anything in your mouth, cough, regurgitate, chew gum, chew tobacco, anything that could potentially skew the breath test result higher. They want to guard against mouth alcohol interfering with the breath test. So the idea is that if you have gum or anything that's in your mouth, or if you cough up something, that it could have some alcohol molecules in it, and then when you blow, it can skew the breath test results. So they're required to observe you for 15 minutes to make sure that none of those actions occur. Officers routinely say we observed this subject for 15 minutes. Most of the time, it is very difficult to prove that they didn't. Most of the time, we know that they didn't, but we have trouble proving it. Occasionally, there are ways that we can prove this, and one of the ways is to subpoena the MDTs, mobile data terminal communications from the officer's vehicle, and their GPS that comes along with their GPS coordinates, and then the AVLs. You can find out where the officer was at what time by the GPS coordinates in those communications, and you can see what time they arrived at the station. And there have been several cases that we didn't have much else to go on, but we to the judge that it was impossible for the officer to have maintained a continuous 15-minute observation period based on the time they were at the scene and the time they arrived at the station. It wasn't possible, and we've gotten many breath tests suppressed that way. So don't always accept the statement from an officer that they did a 15-minute observation period, because a lot of times they're in a hurry. They don't have time to do it. They don't want to do it. They don't know that they have to do it, and they'll just tell you that they did it because they know that you can't prove it. So here's another thing about the 15-minute observation period. It has to be done by a certified breath test operator in the state of Texas. So you can't have an officer bring a person in and transfer custody to the breath test operator and have the first officer watch them for 7 minutes and then the breath test operator watch them for 8 minutes. It can be more than one officer combined to cover the 15-minute observation period. It can be 1, 2, 3 officers that combine for a total of 15 minutes, as long as they're all certified breath test operators. But you can't have one of those people in that 15 minutes that is not a certified breath test operator. If you do, it's not admissible. We had a client that was arrested one time down in Tiki Island, and Tiki Island has their own municipality and their own police department, and there was a breath test. So I called down there and looked on their website. There was about 8 people's picture on their police department website page, and I just said, hey, so I'm representing this person, and they took a breath test on this machine, and it was Officer so-and-so. And are y'all certified breath test operators? And they said, oh yeah, we are. And I said, okay. So it was worth a shot. Didn't get the answer I was looking for, but then right before I was about to let her go, she said, oh wait, do you mean on the big machine? And I said, yes, the big machine, the Intoxilizer 5000. Because there's little handheld deals that troopers use sometimes, and they are not admissible in evidence. So we were talking about the big machine. She was thinking about the little handheld machine. She said, oh no, none of us are certified on the big machine. We got to take them over down the road to get it, just to have them blow on the big machine. I was like, okay, thank you very much. that breath test got thrown out, the case went away, we got the case dismissed. So it's very important. All right, we're done with that question. And let's see. All right. So thank you for that answer. You're welcome. I have another question. How does the blood draw warrant non-consensual procedure work? Well, if you are asked to give a blood test, you pretty much can't refuse down or hold you down and stick a needle in your arm and draw your blood. It's if you see a picture of these chairs, they resemble what you might think an electric chair would look like. They're hard plastic. They have straps around the torso region, the arms, and the feet. As a matter of fact, the Travis County elected official district attorney, Rosemary Lehman, she got strapped into one of these chairs because she got pulled over for a DWI after going to a movie and was arrested and was not cooperative and kept saying, call the sheriff, who she was mentioning by first name. And she was pretty nasty about it. And they had to put a spit mask over her face because she was not cooperating. And they strapped her down in the chair and drew her blood. She did not resign from her job, even though she is in charge of prosecuting people charged with these types of cases, felony DWIs. But she took her punishment and kept her job, even though Rick Perry, the governor, encouraged her to resign. She still did not do it. But I think there's a lot of politics going on up there in Austin. But so the blood draw warrant procedure, here's how it works. If you're asked to give a specimen of your blood, and you consent, which you shouldn't do, then they don't have to get a warrant. Then they can just go in and draw your blood, and that's that. But they're going to get your blood one way or the other, so you might as well refuse and then make them get a warrant, because I think it's an illegal search and seizure issue anyway, and if you consent, then we can't appeal that issue. I think it's an unconstitutional Fourth Amendment violation to draw someone's blood for having some things to drink and then driving your car. So if you refuse, then what the officer does is, actually in Houston, they will just there's a district attorney on call, and the DA will compose the probable cause affidavit and write down all the facts that the officer tells them about probable cause. And then they'll fax it over to a magistrate who is at another building. They don't even appear in person. The law is pretty clear that says that the affidavit must be sworn to by the officer, and that they must personally appear before a magistrate. So that got to be cumbersome, and it delayed the process in getting a warrant. So case law has come out and said, well, now those statutes don't really mean what they say, that you don't have to appear personally in front of a magistrate. You can just fax it to us. We don't even have to see the officer. We don't even have to talk to the officer, the person that is swearing to the probable cause facts, and we'll issue a warrant. The magistrate signs the warrant, faxes it back over to the blood draw area. Then they give the warrant to the person who was hired to draw the blood. They draw the blood. The vials are given to the officer, and then they're eventually turned into the crime lab. So it's the process or the statutes regarding the warrant process had integrity built into them, and that's been eroded in an effort to efficiently and quickly violate somebody's Fourth Amendment rights and draw their blood. So now basically you've got a prosecutor writing a probable cause affidavit. They send it to a magistrate, or they're already over there, get the magistrate to sign it and just fax it back over. And the officer that is swearing to it never appears in front of a magistrate. There are some exceptions to that. Some officers still do, but 99% don't. Okay, we've got some new questions from some new visitors on our web chat today. That's exciting. Thank you, Andrea. So Andrea's question is, does an officer, did I see Corey on there as well?
Yes.
Okay, cool. Corey, thank you for joining, and I will answer your question right after Andrea's. Does an officer actually appear before a judge to get a warrant signed? Okay, well, I kind of just answered that one. How thoroughly does the judge review the officer's affidavit before signing a warrant? Do you find a lot of mistakes made by the officer in the affidavit? So the first question we answered, an officer does not actually have to appear before a judge to get a warrant signed to draw your blood. How thoroughly does the judge review the officer's affidavit before signing a warrant? Well, we know this by experience, and it's surprising. And we were in trial last week where even the judge said, why can't they just get the warrants right? They never get warrants right. I would say 50% or more of the warrants that we receive and we see have mistakes in them. I don't know what's so difficult about reading a probable cause affidavit. If that's your job as the magistrate, to read it for accuracy, make sure the person's name is right, their date of birth is right, their license number is right. Make sure that it actually states probable cause to issue the warrant, that you can prove the person was actually operating a motor vehicle, that you actually can prove that there was the odor of alcohol on their breath, or there's some other reason to think that they were intoxicated. These are the kind of mistakes that we find. Sometimes they leave out some of the fill-in blanks on the computer. They're just completely blank. We had one that had, it said like computer error with question marks, wrong names, wrong dates of birth, wrong times. That's a major problem that we find, that the warrant is issued before the probable cause affidavit is ever even signed. And that's the case that we have on appeal right now, where the warrant cannot issue legally before a probable cause affidavit is signed, sworn to, filled out, sent to the magistrate for his review. But magically, we have warrants that are issuing before that probable cause affidavit ever was signed and blood being drawn. Sometimes we find that the time of the offense is wrong, off by 8 hours. We had one recently where the probable cause affidavit stated that the event occurred 8 hours after the blood was even drawn. So apparently it's pretty difficult to pay attention to the facts and review these for accuracy. I apologize if the rain is getting too heavy. All right, Corey Roth, thank you. Client is a Spanish speaker. He does well on the standardized field sobriety tests that were administered in English. Okay, client tells officer he's having trouble understanding the standardized field sobriety test instructions. The client asks for a DIC 24, which is the statutory warning about driver's license suspensions, to be played to him in Spanish. The trooper plays them in English. Client reluctantly agrees. Is there any case law other than the totality of the circumstances to suppress the breath test? Specific law saying that suspect must get DIC 24 read to them or played to them in their fluent language? Unfortunately, the answer is no. It says that they must be read the statutory warning, and they have to understand it. So while there's no right to have it read to you in your native language, you do have to understand the statutory warnings for them to be valid. That's the argument that you've got to make. If he takes the standardized field sobriety test after the instructions were given to him in English, that's going to probably be difficult to overcome that he didn't understand English well enough, because if he did the test good, that's evidence he did understand English, and I've dealt with that quite a bit as well. If you truly have a Spanish speaker and they don't understand anything, that's going to be obvious from the video and the facts of the case. But depending on what court that's in, you know, you might get further with that than in some other courts. But thank you for the question, Corey. So Andrea also said, if an officer asks me questions about what I had to drink, when I had my first and last drink, how should I answer? Well, you should, at that point, say, I'm sorry, I've been advised to refuse to answer any questions. I'd like to talk to my attorney now. And I don't know, can you hear the rain, Shelley? No? Okay.
I don't hear it.
Guess it has a good condenser mic. Yeah, it's not showing up on the sound bar down there, so I guess it's just getting my voice is pretty funny. It's raining very hard. So the best thing you can do for yourself if you're being investigated for DWI is don't answer those questions. Don't answer what time your first drink was. Don't answer what time your last drink was. If they smell the odor of alcohol, you know, it's probably best to not deny that you have been drinking, because if you deny you've been drinking, then they're probably just not going to believe anything that you say after that. And if you go to trial, the jury won't believe it either. But it's also not a good idea to say, you know, I had like 25 drinks. That can be bad as well. But in order for them to do a retrograde extrapolation, they need to have the time of your first drink, time of your last drink, how much you drank, when you ate last, things like that. So it's best to invoke your Fifth Amendment right to remain silent at that time and don't answer any of those questions. You have a little towel? Okay. Let's see. We got about 4 more minutes. Okay, Justin asked, okay, that makes sense about the warrant procedure. But can someone refuse a blood draw anyway? So the answer to that is no, you cannot. And there are cases where we've seen where they actually hold you down and forcefully take your blood. So you can't refuse a blood draw. Okay, I got one more question, and then we're going to answer this last question and be done for today. Has Uber changed anything about DWI defense? Well, it's probably helped keep some people out of jail that otherwise would have been arrested, but unfortunately, the number of DWI arrests has not gone down, and we haven't really seen an impact on the number of people calling us that have been arrested. So I still think it's a great idea to use Uber and you can be safe, but it hasn't really impacted the overall number of DWI arrests being made in Houston. Okay, last question of the day. How do you attack a blood draw warrant? We've talked a little bit about that. So some of the main ways are, first of all, to find out if it even states enough probable cause for a magistrate to issue the warrant. It's difficult to, when you do so many of these things, it's very difficult for the officer to write it, hurry up and get it done so they can get your blood, and then go back and review everything to make sure that it states sufficient probable cause. We spend a lot of time scrutinizing every sentence and every word of a blood draw affidavit. Andrea. You can read a probable cause paragraph 10 times and on the 10th time find something that you didn't see before, and you say, wait a minute, this doesn't even state that the engine was on, or wait a minute, it doesn't even state who the person was that was driving, or wait a minute, it doesn't even have the date in there or the time in there to find probable cause, or wait a minute, it doesn't even state that they committed any traffic violation. There are so many ways to attack a blood draw warrant, but a lot of times we find problems with the probable cause. There's been times also where officers make false statements, and you're entitled to a Franks hearing under certain circumstances where you get to go behind the warrant, behind the 4 corners of the warrant, and attack the validity of the statements appearing in the probable cause affidavit. And the remedy is you strike those statements inaccurate, and you find if sufficient probable cause still exists after that. If it does, then the warrant stands. If not, then the warrant's suppressed. So we can go into this some more next time. not going to answer that last question that we got, but thank you for submitting it anyway. And we will be back next week in a less rainy environment. But thank you, those of you that tuned in. I really appreciate the questions, especially to Corey for asking specific questions about a case that he's handling. And I'd really like more people to submit questions. I'm here to answer questions about your specific problems that you're having in your DWI case that you're representing people on. Thank you very much. So my name is Tyler Flood, Houston DWI defense lawyer. Submit your questions to us anytime at office@tylerflood.com or call us at 713-224-5529. I will see you guys next Friday at 2 o'clock.